Like our next, that last case is more, oh, no, we might have another one. Our next case here is people of the state of Michigan versus David Bigelow. Case number here is 25-14155FH. Appearances.
Joanna Carey for the people.
I'm Jeff Harrison. I'm here on behalf of David Mark Bigelow. He's joined me at the table, but may I approach the bench?
Yes, sir. Thank you.
I've got kind of clenched up when I stood up. That was why I was wincing a little.
All right. All right, so we're here today for a final pretrial conference. This is the last case pending on the current trial docket for the next trial here in Wexford County.
If I could simply request that you speak up a little bit, Mr. Bigelow. Issues.
Sure. Mr. Bigelow, can you see and hear me now? All right, good. In this case, we're here for a final pretrial conference. This is the last date before the next court date, which is a trial. This is the only case that remains on the docket for the next trial date here in Wexford. Because Mr. Harrison has handed to me a pretrial agreement written and signed by the parties, it says that the defendant will enter a plea of no contest to operating while intoxicated as a third offender. In exchange for that, the prosecutor agrees to dismiss the third habitual felony offender enhancement and the count of driving while license suspended as a second offense. Is that correct, Ms. Carey?
That's my understanding.
And Mr. Harrison?
That's fine as well. Must be Friday.
What was the blood alcohol level here? I'm looking.
159, Your Honor, by the time he got back the blood test. It was well after the incident in question.
Okay.
I will find it. Let me look.
Mr. Bigelow, please raise your right hand. Do you swear or affirm that the information and testimony you're about to provide shall be the truth, the whole truth, nothing but the truth, sir? No. You may lower your hand. So again, sir, I went over that pretrial agreement that I talked about earlier. Is that how you wish to resolve today's case? Okay. So make sure you speak up and I'll do the same. All right. Looking back on October 18th of last fall, were you on probation or parole on that date?
No, I wasn't.
Were you on bond pending any felony allegations on that date?
No, I wasn't.
You are currently charged on a felony information with 2 counts and a sentencing enhancement. Count 1 is a charge of operating a vehicle while under the influence of alcohol and having a bodily alcohol content of more than 0.08 grams or more per 100 milliliters of blood. And because there are at least 2 prior drinking and drivings listed, that becomes a third offense or more, and it increases it from a misdemeanor to a felony. The maximum punishment for that offense is a minimum of $500 to a maximum of $5,000 in fines plus costs. And then the court would have to choose between either a minimum of 1 year to a maximum of 5 years in prison, or in the alternative, a period of probation with at least 30 days of jail up to 1 year in jail. There also could be community service at minimum of 60 to a maximum of 180 days, rehabilitative programming, cost for rehabilitation, cost for emergency response, cost for prosecuting, and vehicle immobilization, which is mandatory, for at least 1 year up to 3 years. Now, there was or is right now a sentencing enhancement called a third habitual felony offender. That could, within the discretion of the court, increase the potential punishment from up to 5 years to up to 10 years. However, if you plead guilty to the count 1, and I accept that plea, the prosecutor agrees to dismiss the third habitual felony offender enhancement, which means it could not be doubled. It would still remain, as I discussed earlier. There is also a count 2 of operating a vehicle while your license is suspended, denied, or revoked as a second or subsequent offender. That would be a misdemeanor punishable by up to 1 year and or up to $1,000 plus vehicle immobilization. I'm told that that charge will be dismissed. So far, Mr. O'Rourke, I'm sorry, Mr. Bigelow, is that what you understood you were doing today? Okay. Now, I have here before me, which was given to me by your counsel, a document that at the top says plea agreement. And at the bottom appears to have your signature right there. Is that your signature? All right. And did you read through it and understand it? Has Mr. Harrison been available to talk to you about the case, talk to you about the evidence and all the options? All right. And are you satisfied with his representation? Okay. Now, on this form at the bottom, it talks about a potential sentencing, and I'll get to that in just a moment. Now, if you enter a plea of no contest, and I accept that plea, you will not have a trial of any kind. I can accept a no contest plea in some circumstances, and what I'm being told here today is that there would be a lack of memory due to the significant level of intoxication. Do you understand? Now, a no contest plea has the same impact as a guilty plea. And whatever the prosecution tells me to review, such as a transcript or police report, that will be forever the truth as far as this case is related. Do you understand? Okay. Now, entering a plea of no contest, if I accept that plea, you'll be waiving certain rights. Now, I'm holding up it here for you to read or see. This form says advice of rights. It appears to have your signature. Once again, is that your signature?
Yes, it is.
Did you read through these rights before signing? And did you understand the words that you read? All right. And even more importantly, once again, you understand that if you enter a plea of no contest, and I accept that plea, you will be forever waiving these rights on this piece of paper, at least as far as this file goes.
Yes.
All right. Now, you also will be given up the right to claim that the plea was a result of any promise, threat, or inducement not told to me right now on the record. Other than the terms of the pretrial agreement, Mr. Bigelow, have there been any other promises, threats, or inducements to get you to plead guilty or no contest? Now, Mr. Harrison's probably talked to you about sentencing. In fact, I see on this one form that I held up earlier, and I'm holding it up again, that there's an estimate that the guidelines would score or suggest to the court a sentence between 0 and 13 months. I highlight for you that the Michigan sentencing guidelines, which are used to establish the minimum end of a sentence for a felony, are not mandatory. They are only a tool I must use, but they do not restrict me. Do you understand? So that tells me Mr. Harrison's talked to you about sentencing. Has he or anyone made any promise to you as to exactly what the sentence would be from this court? And do you still wish to enter the plea of guilty that we had discussed earlier? No contest. I'm sorry. Thank you. Thank you, Mr. Harrison. So as to count 1, how do you plead? Before the court can accept that plea, I need to have something entered as an exhibit. Ms. Carey, what is, or are the people asking the court to consider as the exhibit?
I think do you have the preliminary exam
He does.
transcript?
I do.
I think that's establishes the basis.
All right, thank you. Mr. Harrison, do you agree to the acceptance of that exhibit for the taking of the no contest plea and for sentencing?
I do. I've reviewed its contents and I believe it to be accurate.
Thank you. Madam Clerk, the court reporter, sorry. Thank you. I now have People's Exhibit number 1 in my possession. This is the transcript from the preliminary examination held before the Honorable Judge Corey Wiggins of the 84th District Court on or about November 10th, 2025. One moment. The court notes that on page 41, there is evidence to support that it is a third offense. It talks about prior convictions in the 84th District Court. In a 1996 case and a 1999 file.
The actual certified copies, if you'd like to see those.
No, but sorry, as long as it's in here and they were admitted at that time. So I think that's fair. What I'm looking for, I've already seen everything other than the actual blood alcohol content
No,
listed.
I think we may not have had that at the time of the
Yeah, it talks about,
prelim.
because I see Judge Wiggins's findings where he references 0.08 or conduct that would support it. But
And
if you
that
have-
will stipulate to the entry of the blood test report. Again, it's an exhibit I've seen and I've verified its content.
I'm sorry, Madam Court reporter is marking that for the prosecutor. The court therefore now,
I didn't realize that, Your Honor. I'm
It's
gonna
okay.
clean that out.
the court now receives a People's Exhibit number 2 that is hereby admitted without objection by the defense. And it shows a consistent reference not only as to dates, but names and agencies, and demonstrates a blood alcohol content of 0.159 grams per 100 milliliters of blood. The court also finds that the information contained inside the preliminary exam also covers the dates, the jurisdictions, and the fact that the defendant was operating the vehicle. And it talks about his poor performance in field sobriety testing and his other conduct at the scene with law enforcement. In fact, there's even a BOLO listed that drew the officers to his attention, apparently. Therefore, again, People's Exhibits 1 and 2 have been admitted. Ms. Carey, do you believe that the interests of justice based upon the significant level of intoxication do not require the defendant to recite a factual basis?
I do.
Are you aware of any other promises, threats, or inducements?
I'm not.
Do you believe the factors or facts contained in People's Exhibits 1 and 2 satisfy the elements for count 1 as well as the prior 2 enhancements?
I do.
And I say enhancements, I actually meant the prior 2 convictions for operating while intoxicated in 96 and 99. Do you believe the court should comply with Michigan 6.302?
Yes.
Harrison, do you agree with all that as well?
I do.
The court finds that the interest of justice based upon the significant level of intoxication provide the court with the justification to accept the no contest plea. It's quite clear from it that at the scene, the level of intoxication was very high, and it took a while before they were able to get a blood draw done at the local hospital. The court finds defendants' pleas today are made freely, knowingly, and voluntarily. The court further finds that the information contained in those 2 exhibits today satisfy the required elements of proof for count 1. Therefore, the defendant is found guilty of count 1. Again, that's operating while intoxicated as a third offense or more. Count 2 and the enhancement will be dismissed at the time of sentencing. Mr. Bigelow, sentencing will be in about 4. weeks from this coming Monday. Between now and then, an agent from the Michigan Department of Corrections must prepare a pre-sentence investigation report. One of these reports must be prepared anytime someone is convicted of a felony in a state court in Michigan. The report will include a description of the offense, a description of the pretrial agreement, any statements or information you make or provide, as well as it will include a scoring of the guidelines. The guidelines are, again, not mandatory. It will also include a recommendation. That is strictly a recommendation. As anyone will tell you, I make my own sentences. There are 3 steps that involve you. When you leave this courtroom, you're going to go downstairs to their office. Do you know where the probation and parole offices are located? All right, they're right across the hall from community corrections. There, they will give you a packet. You will complete that packet, turn it back in. Please complete it with as much information as you can. They will also schedule an interview with you, and you have the right to have your attorney present during that time of the interview. And third, Mr. Harrison will meet with you prior to coming back to court to go over the terms and conditions of the pretrial agreement. I'm sorry, and the PSI, all that, because each side has the right to come back to this court and request corrections or make objections to the contents of the report. Each side wants to make sure that they're as thorough as they can be. You want to pay particular attention to a lot of information and make sure that it is all about you and not any errors. I'm going to look at prior performances on bond, probation, parole. I'm going to look at how often you've had convictions, if they've had any overlaps, things like that. Okay. I also want to know if you've been to programming, treatment, rehab, how well you did, or if you failed out of it or whatever. I want to know all of that. Do you understand? All right. Ms. Carey, any objection to the continuation of bond?
No.
Anything further from the people?
No.
How about you, Mr. Harrison?
Nothing further, Your Honor. Thank you very much.
Thank you. Mr. Bigelow, your bond hereby continues until we come back to court. Please make sure you're compliant. If you aren't getting any treatment, I really encourage that you do. Community corrections can help you find